Welcome, Restaurant teammates, to Home Run-In's sexual harassment training. Home Run-In's sexual harassment policy can be found on pages 13, 14, and 15 of your employee handbook. Sexual harassment is a serious issue in the workplace. To ensure a positive workplace, it is the policy of Home Run-In to provide all employees a work environment that is free of improper and unlawful harassment from a coworker, manager, customer, or vendor. Harassment in any form will not be tolerated. All employees are responsible to help assure that we avoid harassment and support a harassment-free workplace, which involves preventing and reporting sexual harassment incidents. Reporting harassment, discrimination, or retaliation, or participating in an investigation will not reflect adversely upon an individual's status or affect future employment. Any employee who retaliates against another for exercising their rights under the policy shall be subject to discipline up to including discharge. All Home Run-In employees are responsible to help assure that we avoid harassment. If you feel that you have experienced or witnessed harassment, you are to notify your manager or human resources immediately at 708-469-3500 or myhr@homerunin.com. Please refer to your employee handbook, which is located on your Paylocity portal, or ask your manager for a copy. Sexual harassment is prohibited in Illinois. The Illinois Human Rights Act makes it a civil rights violation for any employer, employee, agent of any employer, employment agency, or labor organization to engage in sexual harassment. The Illinois General Assembly finds that tolerance of sexual harassment has a detrimental influence in workplaces by creating a hostile environment for employees, reducing productivity, and increasing legal liability. The state of Illinois encourages employers to adopt and actively implement policies to ensure their workplaces are safe for employees to report concerns about sexual harassment without fear of retaliation, loss of status, or loss of promotional opportunities. Employers are required to provide sexual harassment prevention training for all employees. Every employer in the state of Illinois is required to provide employees with sexual harassment prevention training that complies with Section 2-109 of the Illinois Human Rights Act. Every bar and restaurant in the state of Illinois is required to provide employees with sexual harassment prevention training that complies with Section 2-109 and 2-110 of the Illinois Human Rights Act. All employees, regardless of their status, for example, short-term, part-time, or intern, must be trained. If an employer has an independent contractor working on site with the employer's staff, the independent contractor should receive sexual harassment prevention training. What information will be covered in this presentation? An explanation of sexual harassment consistent with the Illinois Human Rights Act, examples of conduct that may constitute unlawful sexual harassment, a summary of federal and state statutory laws concerning sexual harassment, including remedies available to victims, and a summary of employer responsibilities in the prevention, investigation, and corrective measures of sexual harassment. Let's look at what is sexual harassment. Under the Illinois Human Rights Act, sexual harassment means any unwelcome sexual advances, requests for sexual favors, or any conduct of sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, submission to or rejection of such conduct by an individual who is used as the bias for employment decisions affecting such individual, or such conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Types of unlawful sexual harassment. Quid pro quo sexual harassment, this for that, you do something for me and I'll do something for you. This means that a manager or supervisor may not tell an employee that in order to receive a promotion, raise, preferred assignment, or other type of job assignment, the employee must do something sexual in return. Sexual favors are demanded in return for workplace benefits. Hostile work environment sexual harassment. The air at work is full of sexual references and it is impacting me. A hostile work environment may occur when unwelcome sexual advances, requests for sexual favors, or any conduct of a sexual nature has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Observe the pictures below. What do you think? See the correct answers on the next slide. Is this quid pro quo or hostile work environment harassment? I'll give you a few minutes to look over the pictures. How did you do? In our first picture, we see a hostile work environment, nonverbal using the body to communicate. In picture 2, we see quid pro quo. You do something for me and I will do something for you. In picture 3, we see a hostile working environment, unwanted physical touching. Unwelcome behavior, working environment. Unwelcome behavior. Sexual conduct becomes sexual harassment when the behavior is unwelcomed. Behavior may be unwelcome in the sense that the victim did not solicit or invite it, or in the sense that the victim regarded the conduct as undesirable or offensive. Welcome behavior can quickly become unwelcome behavior. What starts off as welcome behavior, consensual joking, can cross a line and become unwelcome behavior. Also, consent can be revoked at any time. When someone experiencing sexual harassment behavior says, "Stop talking to me like this," it must stop. The perpetrator cannot use a defense. "Well, you started it. You were okay with it at first." Working environment. An employee's working environment is not limited to the physical location where the employee is assigned. The working environment extends to other work sites, including off-site, mobile, moving work sites, locations, and anywhere there is a connection to work. Gender identity and sexual orientation. A person can be the victim of sexual harassment regardless of the victim's gender identity or the perpetrator's sexual orientation. A person can be the victim of sexual harassment regardless of the victim's sexual orientation or the perpetrator's sexual orientation. Employees and non-employees as victims of sexual harassment. The Illinois Human Rights Act protects employees and non-employees from sexual harassment. Employees include coworkers, supervisors, and managers. Non-employees include persons who are not employees but are directly performing services for an employer, such as contractors or consultants, independent contractors, or temporary workers. Victims of sexual harassment can include employees and non-employees when sexually harassed by other employees or non-employees. Victims of sexual harassment can include not only the target of the sexual harassment, but also those employees or non-employees who are bystanders or witnesses to the harassment. Customers, patrons as victims of sexual harassment. The Illinois Human Rights Act protects customers, patrons from sexual harassment in places of public accommodations, such as stores, hotels, restaurants, theaters, museums, health clubs, and hospitals. Employers are responsible for sexual harassment of customers, patrons when perpetrated by their employees or non-employees. Employees and non-employees as perpetrators of sexual harassment. The Illinois Human Rights Act prohibits employees and non-employees from engaging in sexual harassment. Employees include coworkers, supervisors, and managers. Non-employees include persons are not employees but are directly performing services for an employer, such as contractors or consultants, independent contractors, or temporary workers. Employers are responsible for sexual harassment perpetrated by their employees and non-employees against other employees and non-employees. Employers are responsible for sexual harassment perpetrated by their employees and non-employees against customers and patrons. Customers, patrons as perpetrators of sexual harassment. The Illinois Human Rights Act prohibits sexual harassment of employees and non-employees by customers, patrons, and third parties. Employers are responsible for sexual harassment of their employees and non-employees by customer and patrons. Employers are also responsible for sexual harassment of their employees and non-employees by third parties, such as sales representatives, vendors, and/or delivery persons. Workplace scenarios. Scenario 1, front of the house. Margarita is the front of the house manager at Eats Restaurant and has been with the restaurant for many years. Margarita's goal is to be an assistant general manager someday. The position has just been posted and Margarita is excited and applied for the position. The general manager has scheduled interviews with qualified candidates and Margarita is scheduled for an interview. During Margarita's interview, the general manager proposed that Margarita sleep with him. Then he will make sure that she gets promoted to the assistant general manager position and work alongside of him. This made Margarita extremely uncomfortable. She is worried that she will lose her job if she refuses the offer. A, should Margarita agree to the general manager's terms in order to get the assistant general manager position? B, contact another manager or HR to report the situation? C, quit and work somewhere else? D, none of the above. The answer is B. Margarita should contact another manager or HR to report the situation. Scenario 2. Customers A, B, and C are frequent customers of Big R's Barbecue, and they all come in for dinner one night. They are all seated at a table close to the kitchen's entry and exit doors. Customer C says to customer B, "This is the perfect spot to watch the employees go in and out of the kitchen." Customer A says, "Just be nice and don't do or say anything inappropriate to the employees." Customer C says, "Why not? That's what they are there for." Customer B says, "Yes, let's make them work for their tips." As soon as the server comes out to take the order, customer B says, "Excuse me, darling, what's your special tonight?" Customer B proceeds to place his hand on the server's backside. The server removes customer B's hand and says, "Do not put your hands on me again, or I will ask you to leave the restaurant." Customer C says, "Sweetheart, you will have to work harder for your tip now." How could the situation be addressed? A, assuming the customers stop the unwelcome behavior, the server could accept apologies from the customers, alert a manager of the situation, and proceed with the service. B, the server asks the manager to have another server take the customer's orders and the manager agrees. C, the manager tells customer A, B, and C that their behavior is inappropriate and that if they continue to harass the server or any of the staff, they will be asked to leave the restaurant. D, all of the above. I'll give you a few minutes. The correct answer is D. Each option is appropriate to address the situation. Rationale: if the customer's conduct stops, the server could accept their apologies and proceed. If the server does not choose this route, the server could ask the owner for assistance, such as having another server take the orders. The employer is responsible for making sure their employees work in an environment that is free from harassment and discrimination, that employees know how to report sexual harassment when it occurs, and that inappropriate customer behaviors are corrected. Scenario 3. Todd is a waiter. He's good looking and flirts with the women coworkers. Donna is a hostess. Todd visits her at the hostess stand and usually puts his arm on her shoulder and massages her neck. Donna has told Todd many times that she doesn't like to be touched, to stop. He laughs and walks away. What answer below describes this type of sexual harassment? Quid pro quo sexual harassment? Hostile work environment sexual harassment? Both types of sexual harassment? Or this is not sexual harassment? I'll give you a few minutes to answer the question. The answer is hostile work environment sexual harassment. Although Donna told Todd to stop, he did not listen. Donna should contact her manager and report the situation. Scenario 4. Tamara works as the front of the house manager. James is the general manager. He and Tamara share the only office in the restaurant. James has posted in the office women in revealing outfits. All the guys love the pictures, but Tamara is offended by them, and she has told James this, and he has not removed the pictures. He responded by saying, "It's my office too." A, Tamara should contact HR. B, ignore the pictures because she doesn't want to cause any problem between her and James. Not use the office, sit at a table in the dining room to do her work. All of the above. What is the correct answer? The answer is A. Tamara is offended by the pictures and they are of sexual nature. She should report it to HR. Examples of conduct that may constitute unlawful sexual harassment. Examples of inappropriate conduct. Sexual harassment includes unwelcome conduct of a sexual nature. sexual advances and requests for sexual favors. Examples include pressure for sexual favors or to go out on a date, deliberate touching, leaning over, or cornering another person, sexual looks or gestures or whistling at someone, sending letters, telephone calls, emails, texts, or other materials of sexual nature, sexual teasing, jokes, remarks, or questions, referring to another as a girl, hunk, doll, babe, honey, tootsie, etc., actual or attempted rape or sexual assault, turning work discussions to sexual topics, asking about sexual fantasies, preferences, or history, sexual comments, sexual innuendos, or sexual stories, sexual comments about a person's clothing, body, or looks, kissing sounds, howling and smacking lips, telling lies or spreading rumors about a person's sex life, massaging someone's neck, shoulders, etc., touching another employee such as their clothing, hair, or body. Sexual harassment in online environments. Our conduct online and through social media can constitute sexual harassment even when it occurs off the clock, off-site, or even out of state. Online sexual harassment includes using email, cell phone, texts, internet posting, online comments, blog posts, and social media such as Facebook, Twitter, LinkedIn, Instagram, YouTube, TikTok, and Snapchat. For example, flirting requests or demands to go on a date or to have sex, sending inappropriate pictures or videos including sexual graphic material, using offensive sexual language or comments, cyberstalking someone. Workplace scenarios. Scenario 5, burgers and fries. Customer A walks into a local burgers and fries to-go restaurant and places an order for a double burger and a large chocolate shake. Employee X takes the order and turns to retrieve the food. Customer A says to Employee X, "Will fries come with that shake?" Employee X immediately turns around and says, "Excuse me, what did you say?" Customer A repeats, "Will fries come with that shake?" This time, Customer A is winking and making sexually suggestive gestures and movements towards the Employee X. How can Employee X respond to Customer A's comments and gestures? A. Employee X tells Customer A to stop making the remarks, looks, and sexually suggestive gestures, stating that the behavior is offensive and inappropriate, and reports the situation to the manager of Burgers and Fries. B. If Customer A does not refrain from the unwelcome conduct, Employee X alerts their manager, who then tells Customer A to stop the behavior or leave the restaurant. C. Employee X and Customer A get into a shouting match and start calling each other inappropriate names. D. Answers A and B. I'll give you a few minutes for your answer. The correct answer is D. Both answers A and B are correct. Employee X should ask Customer A to stop the sexually harassing behaviors and inform Customer A that the behavior is inappropriate. The management of Burgers and Fries is responsible for making sure their employees' work environment is free from sexual harassment and discrimination. Scenario 6, the coffee shop. Employees A and B are coworkers at the coffee shop. They have been working together for almost 2 years. Employee B has recently become Facebook friends with Employee A. Employee B sends a message to Employee A through Messenger asking Employee A out on a date. Employee A ignores the message and does not respond. Employee B sends another message through Messenger to Employee A, this time stating, "This could be the best date you have ever had." Employee A does not respond. Employee B sends a third message to Employee A, and it read, "I didn't want to date you anyway. I heard you're a slut." Employee A becomes very upset by the message and decides to share the message with the manager, indicating that Employee B's comments have made it difficult to concentrate at work. What is the responsibility of the manager in this situation? The manager should conduct an investigation into Employee A's comment. B, if the investigation reveals that the conduct occurred, the manager should take corrective action, including taking appropriate disciplinary action against Employee B if warranted. C, the manager should ensure that all coffee shop employees are aware of the coffee shop's policy against sexual harassment and how to report it. D, all of the above are correct. Please choose your answer, A, B, C, or D. The correct answer is D. All of the above are correct. Rationale. The manager is responsible for responding to the employee A's complaint by conducting an investigation and putting a stop to the harassment. The manager is also responsible for reminding employees of the coffee shop sexual harassment prevention policy, employees' responsibilities to report sexual harassment to manager. A summary of federal and state statutory laws concerning sexual harassment, including remedies available to victims. What can I do if I experience, witness, or can become aware of unwelcome sexual conduct? If you experience, witness, or become aware of unwelcome sexual conduct, know that 1. You have the right to tell the person to stop. The initiating and participating persons must stop the unwelcome behavior upon your request. If they continue the behavior or retaliate against you because you ask them to stop, they can be found to have violated the law by engaging in sexual harassment retaliation. 2. You have the right to report the sexual harassment. Several reporting options are available. The options you choose may depend on the nature and severity of the unwelcome conduct of sexual nature. Persons who report sexual harassment or participate in investigations are protected from retaliation. Things you can do if you're being sexually harassed. Trust your instincts. Refer to your employee handbook policy on harassment, pages 13, 14, and 15. Know your rights in the law. Know and seek out support. Tell your manager, tell HR. When it is safe to do so, you have the right to tell the harasser that you want their behavior to stop. Take care of yourself. You have the right to report the sexual harassment. Keep a written record of events, including what happened, who said, did it, when and where it happened, what dates/times, who witnessed the incident, what was your response at the time, your reactions, your feelings, as well as attempts to tell the harasser to stop can be important. Keep copies of all written and verbal communications between you and HR. Reporting sexual harassment options. The choice of how to report an allegation of sexual harassment is a personal one, and these options are not mutually exclusive. You may pursue one or more of the following reporting options. 1. Call the State of Illinois Sexual Harassment and Discrimination Helpline. 2. Report the incident to your manager and HR. 3. File a charge with the Illinois Department of Human Rights. 4. File a charge with the U.S. Equal Employment Opportunity Commission. The information on how to contact these reporting options can be found in your Employee Policy Handbook section on harassment, pages 13, 14, and 15. Call the State of Illinois Sexual Harassment and Discrimination Helpline. If you or someone you know has experienced or witnessed unwelcome conduct of sexual nature in the workplace, please call the State of Illinois Sexual Harassment and Discrimination Helpline for assistance. Calls are confidential. Call 1-877-236-7703 or visit www.illinois.gov/sexualharassment. Helpline representatives can help callers navigate their numerous reporting options and share additional information related to counseling, legal assistance, and frequently asked questions. Workplace scenarios. Scenario 7, the catering game. During an evening work catering event at a baseball game, employee and manager A stopped for a moment to watch the game. Manager A flirted with the employee and occasionally nudged the employee's leg. The employee was startled by the manager's behavior but did not say anything because of the manager's position. After the catered event, Manager A texted, emailed, and called the employee on a regular basis during non-working hours. The employee told Manager A to stop texting and emailing, but the behavior continued. The employee didn't report the matter further to fear of a job loss as the family breadwinner. On at least 2 occasions at different catering events, 2 other managers, B and C, witnessed the behavior of Manager A and advised the employee to just keep your head down. When the employee and manager had a disagreement, Manager A warned employee to be careful because of the employee's health condition and need for health insurance. What are the employee's options to address this situation, and what are the responsibilities of managers B and C? A. Employee should report this situation to Human Resources, the owner, or any person designated by the company policy to receive sexual harassment complaints. B. The employee may file a charge of discrimination based on sexual harassment with the Illinois Department of Human Rights against the employer and Manager A. C. Managers B and C should report the conduct to Human Resources Office, the owner, or any person designated by the company policy to receive sexual harassment complaints and an investigation should be conducted. D, all of the above are correct. Please give me your answer. I will give you a few minutes. The correct answer is D, all the above are correct. Rationale. Employee should alert the Human Resources Office so that an investigation can be conducted. Employee can also file a charge of discrimination. A charge of discrimination for sexual harassment can be brought against both the employer and the individual who is engaging in the unwelcome conduct. In this case, Manager A. Managers B and C have the responsibility to report the conduct and cooperate with the investigation. Scenario 8, a bartender's dilemma. On a daily basis at the Sunset Bar, servers B, C, D, and E called bartender A, gay preacher, and a pedophile. Server B repeatedly grabbed bartender A's buttocks and pinched bartender A's chest. Manager 1 witnessed the behavior of servers B, C, and D, and E on several occasions, and sometimes joined in as servers B, C, and D, and E laughed at bartender A. The actions taken by servers B, C, D, and E occurred during work hours in front of different managers, including Manager 1, and in the employee break room and restroom. Could the conduct of servers B, C, D, and E toward bartender A be considered sexual harassment? And if so, are the managers liable? A, the situation is not sexual harassment because the conduct is occurring because of the bartender's A's sexual orientation. B, whether the situation is a sexual harassment depends on whether the bartender and the servers are male or female. C, the conduct could be sexual harassment because servers B, C, D, and E are engaging in unwelcome conduct of a sexual nature towards bartender A. D, the managers of the Sunset Bar are not liable because Manager 1 only laughed but did not otherwise participate in the conduct. Please provide your answer. The correct answer is C. The conduct could be considered sexual harassment. Rationale. The conduct of the servers towards the bartender was unwelcomed and of a sexual nature, and therefore it could constitute sexual harassment even if the sexual orientation, for example, gay preacher, is referenced. The gender of the bartender and the servers are not relevant to whether sexual harassment occurred. Because Manager 1 and the other managers are supervisory employees and in a position of authority, the Sunset Bar is automatically liable for the conduct towards the bartender. Reporting sexual harassment to home and in. Report the incident to one or more of the following employer representatives. 1, your manager or any member of management. Managers and members of management are responsible for knowing the employer's internal complaint investigation and resolution process. Managers can help effective, immediate, positive change. 2, human resources will work with management to investigate and resolve sexual harassment complaints. This option may be preferred if the perpetrator of the sexual harassment is a manager. Reporting sexual harassment to the Illinois Department of Human Rights. The Illinois Department of Human Rights is a state agency responsible for enforcing the Illinois Human Rights Act, the state law which makes it illegal to engage in sexual harassment or retaliation. Complainants, victims of sexual harassment, may file a charge at any time within 300 days of the incident. The Illinois Department of Human Rights has jurisdiction authority to investigate employers who have one or more employees. To start the process, submit a complaint information sheet to IDHR. Remedies available under the Illinois Human Rights Act. After the Illinois Department of Human Rights completes its investigation, the complainant, the employee, 1, may file a lawsuit in civil court, or 2, may file a complaint with the Illinois Human Rights Commission if the Illinois Department of Human Rights found substantial evidence of a violation. Complainants who prevail with the Human Rights Commission or court may receive an order awarding remedies allowed by the Illinois Human Rights Act to make the complainant whole. Remedies may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement from front pay, where reinstatement is not possible, and attorney fees and costs. Reporting sexual harassment to the Illinois Department of Human Rights. Contact information. To file a charge, call the Illinois Department of Human Rights or visit them online at 1-800-662-3942 or www.illinois.gov/DHR. Reporting sexual harassment to the U.S. Equal Employment Opportunity Commission. The United States Equal Employment Opportunity Commission is responsible for enforcing the Title VII of the Civil Rights Act of 1964, the federal law that makes it illegal to engage in sexual harassment or retaliation. Complainants, victims of sexual harassment, may file a charge at any time within 300 days of the incidents. The EEOC has jurisdiction authority to investigate employers who have 15 or more employees. To start the process, call the EEOC or their website. Remedies available under the Title VII of the Civil Rights Act of 1964. After the EEOC completes its investigation, the complainant, the employee, may file a lawsuit in federal court. The EEOC may help parties reach a settlement through an informal process called conciliation of the EEOC's finds reasonable cause to believe discrimination occurred. Complainants who prevail in federal court may receive an order awarding remedies allowed by Title VII to make the employee whole. Remedies may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement from front pay, where a reinstatement is not possible, punitive damages, and attorney fees and costs. Reporting sexual harassment to the U.S. EEOC. Contact information. To file a charge, call or visit online 1-800-669-4000 or www.eeoc.gov. A summary of employer responsibilities in the prevention, investigation, and corrective measures of sexual harassment. Scenario 8, a dangerous transaction. Customer was attempting to purchase a drink at the local bar and grill. While passing the drink to the customer, employee A intentionally brushed customer's breast. Customer recoiled and, in disbelief of what had occurred, handed employee A money for the drink. When employee A gave customer her change, employee A again brushed customer's breasts, then laughed and made an unintelligible remark to another employee B. As employee A started to make another gesture towards customer moved out of employee A's reach and fled out of the bar and grill, visibly upset. Who is liable for the treatment for the customer, and what is the best course of action? A. There is no liability for employee A's conduct because the customer is not an employee of the local bar or grill. B. The customer may file a charge of discrimination based on sexual harassment in the Illinois Department of Human Rights against the local bar and grill. C. Employee B should report that they witnessed to a local bar and grill manager. An investigation should be immediately conducted by the local bar and grill, and appropriate disciplinary action should be taken against employee A if warranted. D. Both answers B and C are correct. I'll give you a few minutes to look at your answers. The correct answer is D. Both answers B and C are correct. Rationale. The local bar and grill is liable for the behavior of employee A and is responsible for conducting an investigation and taking appropriate disciplinary action if warranted. Since customer is not an employee of the local bar and grill, customer cannot file a charge against the employee A directly. However, customer may file a charge of discrimination based on sexual harassment against the local bar and grill because it is a place of public accommodation. Is my employer responsible for sexual harassment? Yes, employers are responsible for sexual harassment in two ways. Manager harassment. Employers are strictly liable for sexual harassment perpetrated by its members of management, regardless of whether the employer knew of the harassment. Coworker and non-employee harassment. Employers are liable for sexual harassment perpetrated by an employee, coworker, or non-employees, vendors, only if the employer knew or reasonably should have known of the harassment and failed to take prompt corrective action. Employer responsibilities. The employer responsibilities and liabilities concerning incidents of sexual harassment in the workplace include the responsibilities to prevent the incident of sexual harassment in their workplace, investigate incidents of sexual harassment in the workplaces, and correct the incidents of sexual harassment in their workplaces. Employer responsibility prevention. 1, develop, implement, and regularly communicate the employer's sexual harassment policy. 2, provide training for managers and employees on sexual harassment prevention. 3, ensure clear communication on how to report incidents of sexual harassment or conduct of a sexual nature. 4, managers and supervisors should monitor their work environment to ensure the workplace is free of sexual harassment. Supervisors should be aware of the conduct within their supervision. 5, managers and supervisors must lead by example and model appropriate conduct, refrain from engaging in conduct of a sexual nature. 6, managers and supervisors should conduct a sexual harassment climate check throughout the year, discuss the topic at a team or staff meeting, in service day, or as part of a structural communication such as division/unit newsletters. Employer responsibility. Investigation. 1, immediately respond to a complaint of sexual harassment and initiate an inquiry or investigation. 2, interview the complainant, the victim, and take reasonable action to protect the victim from retaliation or experiencing further sexual harassment during the investigation. 3, interview all relevant witnesses. 4, interview the alleged perpetrator of the sexual harassment. 5, document the investigation results and maintain the file as an employment record. 6, take corrective action as appropriate. Employer responsibility, corrective measures. 1, take appropriate corrective or disciplinary action up to and including termination of employment where organizational policy has been violated. 2, in situations where the conduct in question did not rise to the level of sexual harassment or a violation of policy, but is concerning or may be considered grooming behavior, consider counseling, training, and closer supervision of the employee. 3, take reasonable action within the organization to reduce the likelihood of future sexual harassment incidences by updating policies and communicating them to the workforce, providing supplement or tailored sexual harassment training, or restructuring the working environment or reporting relationships. 4, follow up with the complainant victim at regular intervals to ensure they in the workplace remain free from sexual harassment. Stop sexual harassment. Thank you for joining us today. If you have any questions, please contact Homer Inn Human Resources at 708-469-3500 or myhr@homerinn.com.